3, 2, 1, start. Broadly outlined, the facts of this case are that the respondent, Measures Anand Tools Private Limited, filed complaint against the present petitioners, which is incidentally having a little bit similar name, that is Measures Anand Tools Unit Number 2nd Private Limited and its directors. Stop. The allegations in the complaint are that earlier the complainant and the accused had common business and were initially running a joint business. Stop. However, thereafter the business was separated by the two. Stop. As a result, the assets, rights, and liabilities were divided between the parties. Stop. An amount of rupees 18 lakh 52,253 was required to be paid by the accused number 1 to the complainant as a result of the above said settlement as involved in one complaint. Stop. There are other amounts also which are involved in two other complaints. Stop. For discharge of the above said liability, the petitioners had issued check dated 8/1/2009 for the above said amount of rupees 18 lakh 52,253. Stop. For the amounts involved in other complaints, two other checks were also issued. Stop. However, on being presented, the checks were dishonored by the bank. Stop. Resultantly, notices were issued to the petitioners accused on account of dishonor of all the three checks as involved in three complaints. Stop. Despite the notices, the amounts were not paid by the petitioners. Stop. This resulted into complaints being filed against the petitioners under Section 138 of Negotiable Instruments Act. Stop. The summoning orders were issued against the present petitioners in all the three complaints. Para. During the pendency of the above said complaints against the petitioners, they filed applications for compounding of the offences in all the three complaints. Stop. However, since the complainant had not agreed for compounding the offences, therefore the trial court dismissed the applications moved by the petitioners in all the three complaints. Para. Challenging that order passed by the trial court as well as seeking quashing of the complaint and the summoning order, the present petitions have been filed. Para. Counsel for the petitioners has contended that after the summons were issued against the present petitioners in the complaints, then they had also got lodged an FIR against the complainant. Stop. As an attempt for compromising the entire matter, the complainant had agreed for quashing of the complaints at the stage when the complaints had filed application for seeking anticipatory bail in the FIR case lodged by the petitioner. Stop. However, Thereafter, the complainant got dishonest and the complainant tried to get out of the agreement arrived at between the parties. Stop. Hence, the petitioners moved the above said applications for compounding by attaching the drafts for the amounts of check involved in the complaint with further undertaking to pay any more reasonable amount deemed appropriate by the court. Stop. But these applications have been dismissed by the trial court. Stop. It is further contended by the counsel that as per the law laid down by the Honorable Supreme Court in 2010 5 SCC 663, Damodar S. Prabhu versus Sayyid Babalal H. and another judgment rendered in 2017 for RCR Criminal 476 Measures Meters and Instruments Private Limited and another versus Kanchan Mehta. The consent of the complainant is not required for compounding the offence under Section 138 of Negotiable Instruments Act. Stop. Counsel has referred to the judgment of the Honorable Supreme Court in 320 CRPC, which requires consent of complainant, have been held to be non-applicable in case of compounding to the offence under Section 138 of NI Act due to use of non-obstante clause in Section 147 of NI Act. Stop.